Thank you all for being here this afternoon. We were going to do a press conference about something else, but obviously with the attention that the Brady Giglio issue has taken in the media in the last couple of days, I thought it was important for the acting chief of police, John Speer, the sheriff, Jeff Easter, and myself to appear before the cameras and the media today to say a few things. First of all, I want the readers, the viewers, the listeners, the citizens of Sedgwick County to understand that the three major law enforcement agencies in this jurisdiction all understand our obligation to maintain the highest degree of integrity with respect to criminal investigations and certainly criminal prosecutions in this jurisdiction. We take our obligations very seriously, and I hope that the promulgation of the Brady Giglio policy that I sent around to law enforcement this week is some evidence of that. I will also state again, I know this is repeat for several of you because I've spoken, I think, to every member, at least one member of every media organization in the community in the last few days to state this, but I'll say it again because I believe it is very important and needs to be restated, and that is this does not mark some new event in the course of history in Sedgwick County. This is a policy and a practice that we have long undertaken. That is to ensure that defendants who are accused of crimes, whether they be misdemeanors or felonies, are given every opportunity to defend themselves by being given full disclosure of the discovery. That includes information related to witnesses against them. Those witnesses would be civilian witnesses or law enforcement witnesses. Again, this is a practice that we have long had. Has simply been made clear to me, and it was my decision ultimately that this was something that needed to be put into writing to add clarity to what struck me as a very obvious position. The position of this office, this district attorney's office, is that we will continue to take into this, ask for this information from law enforcement. We have received nothing but cooperation from the Wichita Police Department and the Sheriff's Department in terms of providing information about their employees that would fit the criteria set forth in my policy. We have been taken that into account and identified any potential issue in any active case. We then, for the last many years, have then told the defense attorneys, disclosed the same to them, which is why you haven't seen issues coming to your attention in the media or in the courts of appeals of the state for violations of Brady Giglio. There haven't been any because we have been in compliance with the rules. I simply made a determination that it was time to put this into writing and give it to all the law enforcement agents in the state. I would tell you, in the jurisdiction. I would also tell you that I was present today for a meeting of the small town chiefs of Sedgwick County, all the smaller localities, smaller jurisdictions, law enforcement jurisdictions, talking Derby, Andale, Genie, etc., and made sure that they also had received the letter and the information they all had, and was able to answer any questions that they might have had. And I'll be candid with you, there were no questions. They understood it very well, and again, I expect nothing but continued compliance with what we've come to expect from our law enforcement partners in this community. So the big point of this conversation today, the reason I felt it important to do this is when citizens get their jury summons and come to this courthouse and sit in judgment on their fellow citizens who are accused of crimes, I want them to understand and know that when they get here, that when the district attorney's office and a representative of this office stands up and says, appearing on behalf of the state of Kansas, we take it very seriously and we mean what we say, and that when they come and listen to evidence, they can know that it's been properly vetted, that all obligations under the Constitution have been complied with, and the highest degree of integrity has been adhered to by this office and all of the law enforcement jurisdictions in this community. So if it sounds like I'm making a speech, sorry, but I mean every word of it, and this is very important and it's worth having this conversation today. I'll defer to either the acting chief, Speer, or Sheriff Easter. Jeff, you're on my right. I'll let you go first if you'd prefer.
This is a very serious issue. It's been a very serious issue that's been facing law enforcement for several years now. And as Mr. Bennett had stated, we've been in compliance with this policy. I asked him specifically to place it into writing so that I would understand exactly how to manage this issue. As all of you know, we have 8 current employees that have Brady Giglio material for various reasons. Those folks currently were told about the current ruling that has taken place, and we are now trying to find out what the ramifications of this will be. And so, there is the biggest thing here is that we make sure that we still maintain the citizens' confidence that the sheriff's office is always going to provide the utmost amount of integrity to prosecute cases and to take care of the victims to ensure their cases come to court. Therefore, there is some folks that are in detention, which they're not commissioned deputies. They do not have to file affidavits, have very little chance of testifying. And then we have some deputies that are commissioned. Those deputies are no longer working and have not been working for quite some time in a street capacity. They are positioned in other parts of the department, such as the Judicial Division and the Transportation Division, which does not expose them to any type of cases that they would make for victims, or does not expose them to making arrests out in the field. Now again, it limits their exposure. Could there be an issue in a courtroom that they would have to handle, that they would have to testify to? Yes. That would be, such as the policy has said, that it would be a case-by-case basis that would be looked at by the district attorney's office. So, with that, we do take it very seriously. I can't answer any questions on what this means to the future because we don't know. We are looking at all different avenues and how to address this particular situation.
John?
The Wichita Police Department has 26 employees. Let me start over. The Wichita Police Department has 26 employees that have been reviewed in most cases and found to have either Brady or Giglio impairment. Some of the news media outlets have requested information which has been provided by our law department, kind of breaking down the assignment of where these employees are at and the reasons that they are Giglio or Brady impaired. As the sheriff said and as the DA has said, this is not a new issue to law enforcement. It's something that we've been dealing with since 1963 and 1972. However, in recent years, there have been some cases in the public where this has really come to the forefront, and there's been a lot of scrutiny and questions and concerns involving this, not only in Wichita or Kansas, but throughout the United States. We've spent a lot of time working with the DA on this matter. We've done training with the Kansas Law Enforcement Training Center in Hutchinson regarding this matter, and are trying to work with our counterparts throughout the state. As you know, Wichita is the largest police department in the state of Kansas. We have well over 800 employees, not all of them commissioned. We have support staff, administrative staff that are non-commissioned that are also Brady and Giglio impaired. And at that point, I will, I guess, open it up for questions.
John, when you look at this list, it talks about 2 felony.
What list? Which one?
The Brady
Okay.
Giglio. It talks about 2 felony convictions. Can you address that?
I'll merely say that the 2 felony convictions are not commissioned police officers. And I'll.
Can you say if they're in the
Pardon
distant
me.
past?
I'm sorry.
Can you say if they're in the distant past when they occurred?
The felonies?
Yes, they were pre-employment.
I think it's one of the things that's important to note that I know in dealing with these issues with both the police department and the sheriff, that many of these issues these issues precede certainly Sheriff Easter and precede the current manner of assessment of these in the Wichita Police Department. A lot of these things happened long ago, and they're being, if they were to happen today, I think the response would be certainly different under current policy.
And John, on the support service personnel, who falls under support service? Because when you look it up online, it's like the command staff, basically.
The long explanation is field services falls under Deputy Chief Mosley, and support services falls under me, and investigations falls under Deputy Chief Ramza. The exception to support services is that I also have internal affairs, and they fall under the chief's office. But we also have records, training, and areas like animal control and all of the specialty units.
Does the position of the chief fall under support service?
Within the organization, yes.
And is this list current as of today?
It is current as of today.
And John, we just have to ask specifically, is there anyone, the chief of police included, that falls under Brady Giglio?
Deb, we're not going to comment on that, and obviously I know that there's been questions, there's been comments about that. The city manager is aware of that stuff, and I would refer you to the retirement or any matters involving the chief of police to the city manager.
On the list that we were provided from your department and then also from the sheriff's office, the sheriff's office gave ranks, and then your office gave just the field services, support service, and investigations. And it looks like what we're being told is that to give ranks would be not open records. Can you tell us why it's different from your department versus the sheriff's
I'm
office?
going to step in at this point. If you want to ask these questions to the city and on the city's time, that's fine. I think this meeting here is of a larger, let's put it this way, we're here to talk about some of the larger issues with regard to Giglio. I'm not going to, it's appropriate obviously to ask that question. I just think here in this context, the sheriff and I guess I'd appreciate it if we'd have questions that were more directed toward the policy and the manner in which these issues are going to be attended to by the various agencies. Yeah, you can understand why I think it's appropriate. These are questions that are more appropriately sent to maybe the manager or to city spokesman.
What does it mean to be Brady or Giglio impaired?
Again, you can look at I've got a copy of it if you don't have it already. The policy itself talks about anyone, and this again is a policy that I put it into a policy, but the truth is it's a status that's established in our case law, the United States Supreme Court. It talks about any person who has something in their past that would allow the defense to ask them questions of an impeaching nature. So I'm trying to put this in not so much legalese. If I can ask you questions about your past that help me undermine your credibility, that helps me defend myself. If there's something about your past that would allow me to do that, that's impeachment information. If I, as a district attorney, as a prosecutor, know that this witness has impeachment information in their past, I got to tell it to the defense attorney so they can use it. I can't tell you how many times I've had to, often the people who are present when crimes are committed are people with criminal records. And so a guy with a forgery in his past, a guy with bad checks in his past, a guy with thefts in his past or burglaries, maybe the witness to a drug deal, to a crime, to a murder. That doesn't mean they can't testify, but it means that I cannot put them on without disclosing to the defense attorney what the nature of this guy's history is so that he can adequately defend his client. All this policy discusses, all these laws that are referenced in my policy point out is that police officers, sheriff's department deputies, anybody who would testify is not exempted from that. The policy applies to all witnesses. The one thing that's unique about law enforcement officers is they do bring affidavits to the office. The average citizen does not. So that's one point of distinction. But that's in a loose nutshell. That's what Brady Giglio means. That's why that's the type of information that we would be in possession of, and that would include in the realm of law enforcement. Do they have not just a conviction for a shoplift in their past, but have they ever been identified as having an issue with truthfulness? Did they say that they were on duty that day when they actually were off duty for 2 hours, and they were found to have been less than truthful in their submitting their hours for the week? That could be a truthfulness issue, and it could be something that a defense attorney could make some use of in defending their client.
So the defendant would be able to get that information in any case?
In a case that the person is being brought against, say that again, if the witness is being brought against them, yes. That makes sense?
Yeah, and if this was a law before a U.S. Supreme law, then why now clarify it at a local level?
it's, as John mentioned a moment ago, the first case, Brady, came out in '63, Giglio was '72, I believe. There have been other cases that have, you have a big issue like this, discovery. Each case that comes down the pike hones the issue, clarifies the issue a little bit more. This notion that this would include personnel files of law enforcement agencies was not part of the original Giglio decision specifically. That was having to do with a co-defendant who had a deal on the side with the prosecutor. But as that case law has evolved, has been cited to throughout the 70s, 80s, and really into the 90s. About 95 was the first time there was a hint that it would be applied, but even that case, Kyles versus Whitley, didn't go that far. It's not until the 2000s where it starts to, at the federal district court level, where you start to see examples in the case law where that is explicit. And then in the last few years, last 5 years roughly, the DOJ, Eric Holder, his department has issued orders to the U.S. attorney's offices concerning Brady Giglio and the manner in which they'll handle that information and seek it from law enforcement agents, which has caused sort of a ripple effect across state agencies across the United States. This is something, if you look into it, you'll find it from Washington State to Florida, Maine to California. This is not at all unique to Wichita, Kansas, or Kansas in particular. But that's the sort of the arc of this law and its application to the state courts.
Chief, a byproduct of this whole story is that how do you reassure the public that the officers that they encounter don't have criminal records, or how do you assure them that the people that they're dealing with aren't
Impaired.
Yes.
Obviously, these are things that we're going to need to not only tackle on the Wichita Police Department's level, but also county-wide. Law enforcement has struggled with this coast to coast, border to border, as Marc has said. These are things that what we want to do is be in unison with the other agencies around here, and these are going to be things that we're going to work with the Sheriff Department and the other chiefs throughout the 18th Judicial District on these matters and how we're going to go about handling these employees. We're also, ours is a little different because we also have the Fraternal Order of Police. We're going to bring them in and also work with them on this issue. So this thing is evolving currently, and we're looking at everything and have a lot of work to do in the future on this.
Marc, you spoke with a colleague of mine yesterday. You said that we're not talking about cops who've been stealing evidence from the property and evidence section, or who have gone out and committed robberies and thefts, things like that. If there's somebody in law enforcement who's done that, they're fired. You said we're talking mostly about minor personnel violations. Given the list that's been disclosed to us today, the fact that there are 2 felonies and several misdemeanors, do we know for certain that there aren't officers on that list who were stealing evidence or things like that?
Yeah, I mean, again, that's what the point I made earlier. These are, I remember who asked the question of John a moment ago. Most of those are historical issues. If an officer under the current policy, both the Sheriff's Department and the Police Department, as I understand it, if an employee were to commit crimes like a crime, they'd be gone. We're talking about these are folks who
We're kind of
historically,
under the umbrella.
but the vast, or not under the umbrella, but preceded the current policy, as I understand it, and no, I just think it's important to understand that most of these things, I think it was Tim in his article yesterday wrote an example of one retired officer who mentioned what had happened to him, and it was really a fairly minor offense. But we don't have a sliding scale of offenses here. I don't say, well, that's not a big deal, I'm not going to disclose that. Or that was 30 years ago. They got a shoplift when they were in high school 30 years ago. Who cares at this point, right? There's no sunset, there's no sliding scale. We have an obligation to disclose the information, and it may not even be admissible. But that doesn't decide the issue. We have an obligation to disclose the information, and then the defense has the opportunity to defend themselves in light of all the information, not just what I think they should have.
So we will likely not find out what those felony convictions were, or any of those misdemeanors.
I can't speak to that. That wasn't a request made to this office. I'm answering your question directly in terms of how this affects cases moving forward. Jeff, you were going to say something?
Yeah, to clarify a little bit of what you're asking about is, there is a time that law enforcement would hire individuals that when they were 14, 15 received a shoplift conviction, which was a minor crime. You went through their backgrounds, a lot of distance in between those things, and we would hire individuals that had that minor offense. Due to the Brady Giglio material, we no longer hire people like that. And so, when you're talking about that, that means that our pool is even littler now because people do make mistakes, and they make a lot of them when they're teenagers. And now in law enforcement, you're not ever going to be forgiven for that. And so I'm not saying that's good, bad, or indifferent, but what I'm saying is that within the sheriff's office, when you see, if there's folks on there that have misdemeanor convictions, those type of things, that's how it happened. It didn't happen while they were employed. And so, you also have to understand from a government is different than private. In the private industry, they can walk into you right now and say thank you for your service, and you're gone. In the government, the Wichita Police Department deals with the union. We deal with the Civil Service Board. And so what that means is those deputies and officers have due process. And then a Civil Service Board rules whether or not I can actually terminate. And the FOP, through a grievance procedure, the grievance procedure rules whether or not they can be terminated. And what we feel as managers should be terminated for can be overturned, and has been in the past.
I want to add to that, when Jeff was talking about hiring, the Wichita Police Department, as of in the past 24 months, we now have a policy that that applicants with any crimes or convictions of dishonesty are not eligible applicants for the department, and that includes shoplifting, checks cases, theft of services, false police reports, anything along those lines. So there are things that we have done to already, but we understand that this is constantly evolving, and there's things that we need to look at more on a global level in how it impacts law enforcement in Sedgwick County.
Just
Go ahead, Mark.
one more, and then I'm going to wrap this up and circle back to a question you was asked. Go ahead.
Oh, I was just gonna ask you, John, on the officers who are on the streets, how do you, if they work a crime and they have to have an affidavit given to Marc, how do you know what they're telling you is true? And I think in your ruling, you said that you wouldn't rely on those affidavits anymore. So I guess this is kind of a question for both of you.
Well, I think this kind of harkens back to the question I was going to get to just wrap this up. The question he asked a moment ago was, well, how do the citizens know how can they be sure that the police officers, the deputies who respond to their calls, that he didn't go so far as to say this, but the jurors who sit in these cases, when they sit and listen to somebody testify, how can they know that they can give credibility to those witnesses and to those police officers? The thing you need to think about is what both of them have said. That is that both the police department and the sheriff's department, and I will presume to speak for a moment on behalf of the other smaller jurisdictions, the Derbys, the Andales, etc. Law enforcement is going to do everything they can to keep people with these issues out of a position where they have to be put in a position where they are the only witness to a crime. They can provide information to the detective, and so that the detective can then vet it, look for other objective evidence, the detective who doesn't have these issues can then do the entire investigation, bring that to the office and file an affidavit with the office. We will then vet it also to see if we believe there's sufficient evidence that the crime was committed. But if that witness, that officer, that deputy who has this designation in his or her past comes up and they are potentially a witness in the trial, they can be a witness in the trial. There's nothing about it that says someone who made a mistake when they were in high school is somehow now not allowed to testify. If that were the case, there'd be a whole lot of civilians walking around who wouldn't be allowed to testify. Kansas law presumes that every person is allowed to testify. Every person is qualified to testify and be taken at their oath and be subject to cross-examination. That's the manner by which we test credibility. Anton Scalia, again, I'm sounding preachy here, but the United States Supreme Court has even said that the rubric of cross-examination is the means by which we test credibility. The point is, we vet it, and this office doesn't look the other way. This office won't say, it's not, are you kidding me? A shoplift when they were 14? Who cares? What the citizens of this jurisdiction need to know is that law enforcement is attending to this. They're doing everything they can to not put these people in the position where they are being set up to have that issue forced. If they are a witness and they do need to get called by this office to testify, we'll vet it. We'll disclose it. And before they testify, before a citizen sits on a jury, before a citizen has to come and testify themselves about something they saw, they should have every level of assurance that the Office of the District Attorney, the Wichita Police Department, and the Sheriff's Department, again, are holding ourselves to the highest level of the law and maintaining the integrity of criminal investigations and prosecutions in this jurisdiction. We could go on for the rest of the afternoon, I'm sure, but this is the message I think is, several of you asked it in one way or another, but that's the message that needs to get out. Law enforcement in this jurisdiction knows the rules. I have made them as clear as I am capable of making them in a written dissemination of the same. We are going to uphold the law. We're going to do so in a fashion that our citizens can be proud of and can have a surety that we're doing it the right way. And you can also know that we're, again, I'll say it one final time, that we are maintaining the integrity of the criminal prosecution in Sedgwick County.
Can I just ask one last
One more.
question? Okay, and John, this is for you, this whole issue with the body cameras and these officers. How important is it, or is it important that they have those cameras on so that you can rely on those for the evidence instead of their word?
You mean trying to mitigate the impact? These are things that we are currently looking at. I just discussed it this morning with the other two deputy chiefs. We've discussed it with our law department and with the city manager. So we are, this is a live discussion right now on this matter, and it's something else that we're going to continue to discuss as the weeks and months go on.